Hi everyone, thanks for downloading this Lead Day podcast. This is hopefully the first of many podcasts and webinars we hope to record that showcase some of the firm's environmental work around the UK and to provide a snapshot of some of the key topics in the environmental law facing us right now. Today's podcast focuses on the recent Court of Appeal judgment concerning Heathrow Airport expansion, in which Lead Day represented Friends of the Earth in their successful appeal. My name is Rowan Smith. I'm an environmental and public lawyer, and I work in the firm's Human Rights Department. And I was lucky enough to be one of the lawyers at Lead Day with conduct of the Heathrow case. I'm very pleased to say that I'm joined by today's guest contributor, Katie Picawa, who is in-house lawyer at the environmental NGO Friends of the Earth. Hi, Katie.
Hi, Rowan. Hi, everyone. As Rowan said, I'm a lawyer at Friends of the Earth, and I was one of the in-house lawyers working on the very exciting Heathrow challenge. It's really, really great to be able to join Rowan on this podcast. So Friends of the Earth is one of the country's leading environmental NGOs. We're the largest grassroots environmental NGO in the world, and campaigning against Heathrow expansion is something that Friends of the Earth has been doing for years and years, going on for 20 years now. So it's absolutely incredible to have secured this victory for climate justice.
Great, and we're going to talk about the judgment, the key decisions made by the Court of Appeal. We're going to have a brief discussion on the wider points of the court's interpretation of standard of review in environmental cases. We're going to have a little discussion also about the wider impact of the Heathrow judgment on other infrastructure project challenges. And here we go.
Before we begin, this is just a short disclaimer to say that this podcast was recorded before the Supreme Court granted permission to appeal to Heathrow Airport Limited. The content of the discussion is all relevant still. On the Court of Appeal judgment, the climate change points will be considered again by the Supreme Court. The other non-climate change points won't be appealed, so the findings on those will stand.
Okay. First thing we're going to do is just have a brief background to the Heathrow challenge. So Casey, do you want to just say a little bit about the background and how Friends of the Earth got involved in this campaign?
So, as I mentioned, challenging Heathrow expansion, resisting Heathrow expansion is something that Friends of the Earth as an organisation and in terms of our wonderful volunteers have been doing for years now. Local communities to the proposed new runway have been campaigning against Heathrow expansion for getting on for a couple of decades, and that has included the wonderful work of our Friends of the Earth West London local group network. And these communities have been fighting expansion for a number of reasons, including environmental grounds and concerns over their health and well-being. And just to put this into context in terms of the local impacts, if expansion had gone ahead, then around 4,000 homes would have been destroyed. So that's really, a case of wrecking communities to the local area. So we've been involved, as I said, Friends of the Earth itself has been involved in this fight for many years now. And an example of that in terms of the legal team's work was back in 2007 when we brought a challenge to knock back a incredibly broad anti-protest injunction, which was taken out by the then owner of Heathrow to try to stifle protests against the proposed expansion then. And that case was successful, but you can see how this menace of Heathrow expansion has sort of come back again and again and again. So we found ourselves in June 2018 with a government which had just adopted the Airport National Policy Statement, which is the government's sort of high-level policy endorsement of Heathrow expansion. And Friends of the Earth decided to get involved in the legal challenge and to specifically bring a challenge in relation to climate grounds. But that challenge was brought in the context of a sustained period of resistance by local communities, and also in the context of a wider global movement which recognises the need to take governments to court when they are burying their heads in the sand and refusing to take concrete action on climate change. So it was very much about a global and a local context. So that's really a sort of brief synopsis of the background to our involvement in it. But Rowan, obviously we weren't the only cases involved, and I think you were going to go on to say something about the other challenges and what happened there.
Yeah, I'll briefly give an overview of the other grounds of challenge that were raised by the consortium of claimants, principally the councils who opposed the scheme. Just to put this in the context of the legal framework, so under Section 5 of the Planning Act, the AMPS could only be adopted after an appraisal of sustainability had been carried out. And for the purposes of the judgment, as you'll talk about in a second, that appraisal sustainability constituted what would otherwise have been the environmental report that the Secretary of State was under duty to complete under the SEA regulations, so the Strategic Environmental Assessment regulations. That's how these next points fit in. We'll provide a link to both the habitats and the SEA regs as well, so you can follow what we talk about. The first ground under habitats regulations that the other claimants brought was to do with the hub objective, which is a catchy description for what the government had labelled as its main aim in producing this policy for airport expansion in the southeast of England. Essentially, the government's position was that Gatwick Airport was rejected as an option because it couldn't, so the government said, satisfy this hub objective. So therefore, it was discounted as an alternative solution. Those arguing this point were saying that exclusion of Gatwick was unlawful, despite Gatwick having, in the course of the policy being put together, being ruled out due to its impact on air quality issues as well. So ultimately, Gatwick was rejected. The use of the hub objective as a criterion in that rejection process was challenged. Fortunately, the Court of Appeal held, as the Divisional Court did, that the criterion wasn't introduced too late and was a reasonable objective under the policy. So the second issue about alternative solutions that the claimants argued was to do with the impact that Gatwick Airport expansion might have on an area of special conservation. Natural England had stated in its consultation response that there would be impact from Gatwick expansion and that would be harmful. The claimants here argued that harm was never properly assessed, so the Secretary of State didn't properly understand the nature and extent of that harm before excluding Gatwick. Although, again, the Court of Appeal confirmed that it was valid for the Secretary of State to reach its conclusions as it did. In any event, the hub objective criterion overrode considerations of harm, which were, in the Court of Appeal's opinion, unrelated to this point. A nice segue into the points I'll talk about on the SEA regulations. There was also a debate as to whether the phrase alternative solutions under the habitats regulations meant the same thing as reasonable alternatives, which is a phrase used under the SEA regulations. The point being here was that Gatwick Airport was rejected as an alternative solution under the habitats regulations, but still included as a reasonable alternative under the SEA regulations. And it was argued that essentially those phrases mean the same thing, it's the same legal test. So it was wrong of the Secretary of State to arrive at a different consideration. Court of Appeal again rejected those submissions and said that even if they were synonymous phrases, synonymous legal tests, then again, coming back to the hub objective, because Gatwick nevertheless was deemed not to satisfy the hub objective, then in any event, the Secretary of State would have reached the same decision, which was to reject Gatwick and approve Heathrow. Moving quickly on to the SEA grounds of challenge. So the two arguments the claimants ran under the strategic environmental assessment were as follows. The first considered whether the Secretary of State had properly outlined the relationship between the airport's NPS and other relevant environmental plans and programmes, most notably local plan that was relevant to Heathrow. It was argued that the Secretary of State was not permitted to take a cumulative approach and needed to look at the individual plans and whether airport expansion would be compatible with each and every one of those plans. The Court of Appeal disagreed and said that because the Secretary of State's role here was to take a strategic approach, that broad assessment was acceptable. And that was how the Court of Appeal similarly treated the other point under the SEA, which was to do with assessment of the environmental characteristics of the affected areas. This was to do with the noise impacts of the third runway. The ANPS was based on indicative flight paths and not actual flight paths. The claimants here said that that was an unlawful approach, but likewise, the Court of Appeal disagreed and said because of the strategic assessment that was going on, an assessment based on indicative flight paths was acceptable. Interestingly, for the discussion we might have on the standard of review, the Court of Appeal went on to talk about this being a technical and scientific decision, which might have impacted its views on whether this sort of approach was rational or not, and whether it required judicial intervention, which it concluded it didn't. So that was a whistle-stop tour of the habitats and SEA points. Katie, did you want to move on to the climate change issues?
Yeah, thanks, Rowan. And as you say, it's really interesting what the court said on the standard of review, which I know we'll come on to, just how high a threshold that clearly is. So I just want to discuss Friends of the Earth's case really in some detail. Our claim was very much based on climate change grounds, and the other claimant to bring a climate challenge was, of course, Plan B Earth, and was a separate ground of challenge. And I don't know about you, Rowan, but for me, one of the many really exciting things about the case was the difference in reception that we got in the High Court as opposed to the Court of Appeal. So, for example, the fact that the High Court found that our entire case was unarguable, and then we went on from that to actually, completely smash it in the Court of Appeal and win on everything. So, yeah, I don't know. Does that happen to you sometimes in other cases, or?
Very rarely. Like you say, it was the U-turn and the degree of the shift that was so surprising, but which probably made winning all the more rewarding.
Yeah, definitely. I think so, certainly. So in terms of the nuts and bolts of our case then, so as you mentioned, Rowan, the Airport National Policy Statement was adopted under the Planning Act, and our, I suppose, Friends of the Earth's principal ground of challenge was in relation to the Section 10 sustainable duty aspect to the designation of the ANPS. And specifically, we argued successfully in the Court of Appeal that there had been a breach of this duty because A, the government had not taken into account the Paris Agreement, B, they hadn't factored in the non-CO2 warming impacts of expansion, and C, they hadn't considered the full climate impacts of the project to the full lifetime of the project, because Heathrow, the lifeline of the project is expected to run till 2085, and the government had only considered the climate impacts up until 2050, despite the fact that they had considered the economic impacts right up until 2085. So this was, in our view, a skewed version of sustainable development, and the Court of Appeal agreed with us on all of those grounds. Just to explain the non-CO2 warming impacts a little, so the government had considered the carbon dioxide impacts of aviation expansion, which are primarily those concerning, aeroplanes in flight. But there's another source of emissions from aeroplanes, including things like nitrogen oxides, and their warming effect. We had expert evidence on this in the High Court. Could be equal to that of carbon dioxide itself. So basically, it meant that the government had potentially discounted half of the warming emissions in its analysis of climate implications of Heathrow expansion. So that was a pretty glaring error. And the Court of Appeal also very, very helpfully, given the context we're in, endorsed the precautionary principle in finding that the government had acted unlawfully in not considering non-CO2 impacts. They said that this was basically not compliant with a common sense approach and a need to have a prudential approach to calculation of environmental risk. And the precautionary principle is one of the fundamental principles in environmental law. And it was really great to see the Court of Appeal endorse this at a time when we have left the European Union and we're in this transition period, because it shows clearly that this is not rooted in European Union law, because they endorsed an interpretation of the precautionary principle found in the Rio Declaration, which of course has nothing to do with the EU. So that in itself was a really important win. And Rowan, I know you mentioned the SEA grounds in respect of other parties' challenges, but of course there was that was one aspect of our successful challenge as well, wasn't it? So in that respect, we argued successfully that the government had not conducted a lawful strategic environmental assessment because they had not considered the objectives of the Paris Agreement, which were again obviously relevant to this decision. So it was really wonderful to succeed on every single ground in this case. It was very much going up against Goliath in this, because there's a huge amount of government support for this. We were also facing two interested parties, two commercial developers in court. And given what happened in the High Court, it was just, as Rowan said, a complete U-turn on that, and all the greater because of it.
And a great vindication of For Friendly Earth's efforts.
The only other claimant that succeeded in the Court of Appeal alongside ourselves was, of course, Plan B Earth, who successfully argued in relation to a separate duty under the Planning Act, Section 5.8, that, again, the government should have taken account of the Paris Agreement, because the Paris Agreement was itself part of government policy. So that was a really important win for the environmental movement from them as well.
Absolutely, because you can imagine if there are any other references to government policy and other environmental legislation, then the same arguments you'd hope could be run. Katie, I was going to ask, because it wouldn't be obvious to anyone reading the Court of Appeal judgment, but as you'll recall, there was quite an important step along this process, which was when we had a pre-trial hearing even before the Divisional Court main hearing, in which the government conceded that the Secretary of State hadn't considered Paris Agreement at all, and made that concession in response to our application for evidence of what, if any, consideration there had been of Paris. How crucial do you think that turned out to be?
I think that was really, really important, actually. I mean, it may not have felt to us at the time in the High Court when we got the result, but it was something that was commented on, in effect, by the Court of Appeal in its judgment, because they very pointedly referred to the government receiving and accepting legal advice not to consider the Paris Agreement. So you can see how that, how it did pan out. And on the basis of that concession, the Secretary of State also had confirmed that they wouldn't seek to prevent a remedy being issued were the courts to find in our favour, because ultimately, you can win challenging court, but then the court can decide to not actually grant any remedy, that is to say, quash or issue a declaration or anything. It's that there's a discretion there, and the defendant can apply for that discretion to be invoked. So in our case, in the Court of Appeal,
a claimant's worst nightmare.
Yeah, Yeah, exactly. Just a empty victory, I think, is the probably quickest way of saying it. But obviously that didn't happen in our case. The government didn't bring that challenge in the Court of Appeal, and I think that would have been largely owing to the concession made.
I agree, and looking back, and maybe this is a good segue to the discussion on standard of review, with the legal test that was applied to whether it was lawful to ignore the Paris Agreement, with that test being set fairly high as the factor needed to be obviously material, otherwise ignoring Paris would have been rational. I just wonder how our case would have played out differently if there had been at least some recognition of the Paris Agreement in the ANPS. Obviously, it predated the net zero target, but do you think we would have struggled to win in those circumstances?
Well, I think it would have been harder for us to win, certainly, but I think that in mentioning a policy, and just it's not enough to just say you've taken something into account, is it? There needs to be a trail of evidence showing that it's been done. It's not just a tick box exercise. So I think it would really have depended on how much they could show that. And obviously Paris was one of the arguments we won on, but it wasn't the only one. And then there's also the SEA point as well, which I know relates to Paris, but it's in a separate sort of issue.
Exactly, it's a duty to take information into account and then reach an assessment based on that. And I think your point's right that the government probably would have been still in a vulnerable position, because our argument all along was that Paris was so fundamentally important that the whole policy needed to be created within the framework of Paris. Otherwise, a passing reference to it wouldn't have sufficed. Luckily, maybe we didn't need to necessarily go down to that granular level because we had the concession, but it would have been interesting to see how it might have played out differently. So that flows nicely into maybe something we can speak a little bit about, which is the Court of Appeal's comments on the standard of review. So for listeners' benefit, when we say standard of review, we mean what intensity of review is the right one for the court to take when considering matters of reasonableness and rationality. And just really quickly on both habitats and the SEA regulations, there were separate discussions of that. The two main cases cited were the Cray's Nest and Edwards. Cray's Nest was relied on by the claimants to say that the right approach wasn't one of the standard Wednesbury irrationality test, but rather a proportionality approach should be taken by the court, which would be a lower threshold to reach for the claimants to establish unlawfulness. And they said that would be the right approach because it would be compatible with EU jurisprudence on that subject. Interestingly, the Court of Appeal said proportionality approach is only applicable when we're talking about interference with fundamental EU rights. And because that wasn't a concern of the Court of Appeal, they dismissed that argument and said that the usual Wednesbury test should be applied, giving Secretary of State quite a wide discretion. Similarly, under the SEA regulations, having cited the findings in the case of Blewett, similarly, the Court of Appeal rejected arguments that any sort of greater intensity of review than that of Wednesbury should apply. Court of Appeal relying on Edwards to say again that there was wide discretion. Katie, how do those conclusions tally with what the same court then found on the climate change points? It seems to me that they may have taken a slightly harsher view when it came to the habitats and the SEA points, but were more willing to scrutinise the climate change points in more depth.
Well, it's difficult to say, isn't it? Because they don't really explain in any huge detail in relation to our grounds as to why they were obviously relevant. But they considered Paris, non-CO2 and the post-2050 impacts all obviously relevant. So I think it's quite difficult to really assess whether the standard they applied in relation to ours was higher or not. It may be, I think one could also say that climate change is so high up in the national agenda, and which is, a result of a huge amount of awakening across a society of the reality of it, that this is something that's, permeated everywhere, including into the courts system. And I suppose, so it's not a case of it being a lower threshold, but just that it is considered in that context to be completely irrational for a government to fail to consider, the most important climate agreement in the world.
Yeah.
But it's hard to say, though, on the basis, I think, of the judgment itself.
I agree, because there was relatively lengthy deliberations on standard review under habitats and SEA regulations, and then they seem to be passed over a little bit on the climate change points. But I guess we, as claimant environmental lawyers, would expect the same rigorous treatment on climate change to apply to any environmental issue. And I think the Court of Appeal's approach demonstrates that, because it's seemingly an outlier in the Heathrow judgment, and that sort of more in-depth analysis is absent from a lot of other judgments. This is a concern of environmental lawyers across the board, and just to mention, Lead A with Friends of the Earth and RSPB did have, in fact, submitted a complaint to the Aarhus Compliance Committee on this very subject. And Katie and I were lucky enough to attend the hearing last year in Geneva.
Well, as you've already said, Billy, it's recognised that succeeding on a rationality challenge is very difficult for environment claimants, because frequently the answer you get is this is a technical area which is no concern of the court, so you're left with no means of challenging anything. And we just don't think that is compatible with the Aarhus Convention, which, amongst other things, guarantees that, or signatories are supposed to guarantee that there is an adequate process for seeking a substantive review of an environmental decision. So, adequate being, the key word there. And so we think that this means that the courts have got to be willing to scrutinise technical decisions. This doesn't mean going into a full-blown merits review, but it does mean being willing to look at how decisions have been formed, and, to ask the question over whether, there are loopholes, things that have been left out, that kind of thing. And that generally the court's incredibly hands-off approach to any technical decision means that it's just not possible to get justice when it should be under the Aarhus Convention.
The Aarhus Compliance Committee being the committee responsible for ensuring that the UK and other member states act compatibly with the UN's Convention on access to environmental justice. I think we're hoping for the Aarhus Compliance Committee to make findings shortly. And I think this all ties in, because even with the success in the Court of Appeal here, it demonstrates how difficult it is for environmental claimants to win on this point. And as Katie mentions, without clear indication from the Court of Appeal as to how it reached its findings on the standard review on the climate change grounds versus the other grounds, it's difficult to know whether and to what extent this sort of approach will be followed by other UK courts.
So just touching on then the wider implications of this case, I mean, this was an absolutely tremendous victory for climate justice, for Friends of the Earth, for Plan B Earth, and for the wider environmental movement. It has been described as the most important environmental case in a generation in this country, so it's pretty hard to overstate how important it is. The Airport National Policy Statement has been left as basically a zombie policy because the court has ruled that it no longer has any legal effect unless and until the government conducts a review of it, which corrects all the numerous legal errors that were identified by the court. The case really threw into light the importance of the role of the court as well, because there's been a lot in the media and by certain politicians recently about, judges getting involved in political activism, stepping into territory which is none of their business. The Court of Appeal's judgment was really clear that this is not what they're doing at all in this case. They are upholding the will of Parliament, which is exactly what they should be doing. Parliament enacted the Planning Act. The government is required to abide by it. They didn't do that. Therefore, this ANPS has been declared unlawful. So that was really important as well. It also, to me, showcased the vital role of campaigning work as well, because as I mentioned at the start, this case was, it was built off the back of years and years of campaigning by local people. And also in terms of Friends of the Earth's particular contribution, the organisation's particular contribution, we actually lobbied for the inclusion of the Sustainable Development Duty in the Planning Act when it was first enacted, and then we've won this case off the back of it. So that was incredible as well. And just in terms of implications beyond this decision itself, we think it really opens up the possibility of challenges to other big carbon infrastructure projects.
Yeah.
So, for example, on the basis of Paris, and that's incredibly exciting too, because, frankly, we really need every single legal avenue that we can get in trying to get government to really take the climate emergency seriously.
Yeah, so two cases that Lead is also involved in off the back of the Heathrow judgment and on climate change issues more widely. One is the challenge that we're bringing on behalf of an NGO called Transport Action Network, and we're challenging the government's budget decision to announce over 27 billion investment in road expansion, essentially arguing that policy was arrived at without any proper consideration of the impact that scale of road expansion would have on the government's stated net zero carbon target, particularly as nowhere in the policy is there an assessment of the share of the carbon budget that the transport network would take up. The simple point being that if the transport sector is responsible for a greater share of the allotted carbon emissions, then that places other sectors at a disadvantage and could potentially jeopardise the country reaching the net zero target by 2050. Similar arguments to some that we ran in the Heathrow case, and we'll include a link, Lead A's press release on that case. And another one listeners might be interested in is the challenge to HS2 that Lead A is bringing on behalf of Chris Packham. We might be talking more about that case in a bit more depth in hopefully a separate podcast or webinar, but suffice to say that challenge is ongoing, and similarly there are arguments to do with the government having failed to properly assess the climate change impact of HS2. So what's the space on that?
Both sound really exciting, and particularly in relation, from my perspective, in relation to the roads strategy, given overall how much work the Department of Transport has got to do in cutting emissions from the transport sector, because they're actually absolutely enormous, aren't they?
Yeah, and another worrying aspect about that is that after announcing this huge investment in roads, the government then said that we should come up with a new decarbonisation plan for transport. So it seems rather after the fact and slightly potentially designed deliberately to lessen the impact.
Certainly sounds very disjointed anyway. And as well as these really, really interesting challenges which are being brought following this Heathrow case, we're also facing the possibility of needing to defend this amazing victory in the Supreme Court, because we're in a rather unusual decision in a public law challenge where the government has confirmed that they're not going to try to appeal this decision from the Court of Appeal, that they accept it. And instead, the two interested parties, so these two commercial developers, Aurora Holdings and Heathrow Airport Limited, are seeking permission to appeal from the Supreme Court. So Friends of the Earth have obviously been working with Lee Day in resisting that application. But ultimately, if the Supreme Court does grant them permission to appeal, and we're currently awaiting that decision, then this will go to the Supreme Court. And if that happens, then of course Friends of the Earth will be defending the decision to the hilt. So
Absolutely.
this is not a this is not a decision that we can allow to be overturned. It's just too important for the environmental movement.
Brilliant. Well, as I said, we will hopefully update you all on the progress of those other cases and whether anything comes of the appeal in later podcasts. So I just wanted to say huge thanks to Katie for contributing and joining me today.
Thanks very much, Fern, for inviting me onto this podcast. It's been great to discuss the Heathrow victory with you. Hopefully, listeners have found this really interesting as well. And if you feel inspired to take action yourself in relation to the climate emergency, then one thing we'd really recommend is that you take a look at this website, www.takeclimateaction.uk. So this is the Climate Action Group's website, which are being set up by ordinary people up and down the country who want to engage with government to force them to take action on the climate emergency. So Friends of the Earth provides material and resources to support with activism and campaigning initiatives. And for example, groups get involved with their local councils to help them to see the need and to apply pressure to achieve the seismic shift which we really need in terms of, for example, energy policy, how we use our land in this country, etc. So do take a look if you'd like to know more. Thanks.
Well, I hope everyone's enjoyed listening to this podcast. If you'd like to get involved in the campaigns, please feel free to use the hashtags on Twitter. So we're using hashtag #NoThirdRunway and hashtag #TakeClimateAction. And hopefully you'll listen to future podcasts on environmental topics. Thanks a lot. Take care.